Senator Hope Uzodinma and his party, the All Progressives Congress, will this morning be greatly relieved, of course, following the decision of the Supreme Court of Nigeria to stick to its earlier decision to declare Senator Hope Uzodinma and the APC rightful winners of the Imo State governorship election. But rather than quell the public outrage that had been building up for some time, yesterday's decision of the Apex Court seems to have scaled up the intensity of debate over the matter. Everyone is having a say, including, of course, lawyers, among whom opinion is clearly divided. In a short while, we'll be joining our Abuja studio to talk about the entire process that ended yesterday with Abiodun-Jelili Owonikoko, a lawyer and senior advocate of Nigeria, an attorney serving Lagos State in appellate practice, arbitration, and investment cases. But first, let's take a look at a report on yesterday's event at the Supreme Court, put together by our Rice Judiciary correspondent, Chima Nwankwo.
The ruling of the Supreme Court evokes a sense of déjà vu. It is obviously one of the most controversial cases the Supreme Court has seen in a while. Counsel for Emeka Ihedioha, Kanu Agabi, asked the court to set aside its judgment of January the 14th, 2020 on the grounds that it is a nullity. However, counsel to Senator Hope Uzodinma counters that the court lacks the jurisdiction to hear the case. Delivering the majority ruling, Justice Kayode Ariwola points out that asking the Supreme Court to set aside its ruling is asking it to sit in appeal over its own decisions, which he says violates the 1999 Constitution. According to him, granting the request will open the floodgates to endless litigation. He says the verdict of the Supreme Court is a finality. Lawyers are divided on the precedent set by the ruling.
This is injustice at its peak. This injustice is indescribably indecipherable. I cannot decipher it. I cannot. What does the Supreme Court that they cannot overrule their own judgment? When it is reached in error, when it's reached concurium, when there are conflicting judgments.
Today, Supreme Court has affirmed its decision that Hope Uzodinma was legitimately elected the governor of Imo State. It has refused the application to set aside its judgment as an abuse of court process.
However, in the dissenting ruling, Justice Santos Mweze notes that the votes which were used to declare Hope Uzodinma winner were in excess of the accredited votes for the election. He then set aside the judgment of the Supreme Court of the 14th of January 2020 as a nullity. He reasons that the court was misled in declaring Hope Uzodinma as governor and orders his removal from office. He holds that a judgment can be set aside. In his words, a judgment or order can be set aside on the merits. This court has the power to overrule itself and has done so in the past, can revisit any decision not in accordance with justice. This court has a duty of redeeming its image. It is against this background that the finality of the court cannot extinguish the right of any person.
The importance of today's decision goes to show the independence of each of the justices of the Supreme Court. The fact that the decision was 6-1 shows that each justice of the Supreme Court has his independent mind to determine an issue before the Supreme Court. The fact that 6 other justices stood on one way does not stop the other justices from dissenting from the decision of the others.
The court, however, held that all parties in the case should bear their individual costs. Chima Nwankwo, Arise News.
Well, that was Chima Nwankwo there at the Supreme Court yesterday. Now we'll go to our Abuja studio to join Abiodun-Jelili Owonikoko, lawyer and senior advocate of Nigeria, to help us review what happened at the Supreme Court yesterday. Good morning.
Good morning. Good morning.
Good morning.
Good morning. Thank you for coming to the morning show and for accepting our invitation. Now, quickly, what's your take on the ruling by the Supreme Court yesterday in the Imo State gubernatorial election matter? Opinion is divided, but will you say that justice has been done? Will you agree with the lordships, the majority in the majority decision that the Supreme Court is final and the finality of the Supreme Court cannot be questioned?
Thank you so much. The decision of the Supreme Court yesterday is consistent with their long-established precedent. I'm referring to the majority judgment. But that does not distract from the peace and force of reasoning in the minority opinion of my Lord Justice Nweze. Sometimes, and we've been clamoring for this, when a divided court pronounces its decision, it makes it easy for scholarly critics to understand the full ramification when you have to view it from the perspective of the divided opinion. I believe that opportunity was offered yesterday. The majority had no choice if they wanted to go by precedent, having regard to their decision in the Bayelsa matter, to take the same stand. It's just too early after that judgment for them to reverse themselves. We all know that the law has made the Supreme Court the final arbiter of all legal disputes, including electoral disputes. And it is not because they cannot get it wrong. It is because there must be an end to litigation, particularly so in matters that are time sensitive. We are fighting over a subject matter that can only last for 4 years. The normal lifespan of an appeal in the Supreme Court could be like 10 years. But when petitions are filed and they travel through the process from tribunal to Court of Appeal and Supreme Court, the entirety of the period allowed is under a year. Tribunal has 180 days, Court of Appeal 60, and Supreme Court 60. So the pressure on them and the deluge of cases that come within that period of time allows us to accommodate some of their probably oversights. It's easy for us to sit down and criticize judgment of Supreme Court, but if we are placed in their position, given the number of appeals they have to hear from the 36 states and the presidential, apart from appeals from pre-election matters, which covers practically every single electable office from House of Assembly to the Senate, and all of that within a period of 1 year. It's impossible with all their erudition and wisdom, and not once in a while to falter. Personally, now the judgment has been rendered, we are entitled to critique the judgment. In my personal view, the judgment of the Supreme Court that was sought to be reviewed was controversial, in the sense that for the first time, we have a candidate coming forth in an election, ultimately getting himself returned as the winner of that election, without all giving account for what happens to the first runner-up and second runner-up. So, and I think we must commend the counsel that went to argue the case for Ihedioha in person of Chief Kanu Agabi. He adopted a bearish position rather than a bullish one, and that saved him the flag of being slammed with heavy costs. He did not go there pretending that the Supreme Court was a forum for him to show their lordship that they are ignorant or they are imperfect. He simply tried to explore the window within the law to see whether they could be persuaded to see the case differently. Unfortunately, that did not happen. But it did not go empty-handed. Sometimes dissenting judgments in some cases come later to become the majority opinion when other occasions present themselves. I believe that in the circumstances, the outcome was predictable, but what was not too obvious was that we are going to get a dissentient opinion from Justice Nweze, who warned that that judgment of the court will continue to haunt our judiciary until some kind of solace is found. I think so far, that's all we can say.
Thank you. Let's, well, you've raised so many questions. I wanted you to please expand on what you said with regards to Chief Kanu Agabi and the fact that he escaped being lambasted by the Supreme Court justices he also escaped a fine. You made a reference to the fact that it was his attitude that created that result. But what about the merits of the case? Is it entirely impossible to suggest that the merits of his application were found valid, which is why he escaped that? And also, you also made several references to the dissenting judgment of Justice Nweze. How persuasive of an authority going forward is a dissenting judgment?
Yes, thanks. First, I had the privilege of reading the draft brief by Chief Kanu Agabi, and I was really excited about it. Having a prediction of how the court will receive his argument. He did not set out to poke their lordships in their faces. He set out to canvass legacy implication of their judgment, and all of them want to retire from the bench with in glory. And the best way to assess a judex's performance on the bench is through their judgments. They must be able to defend their positions after they have left office. And rationally, he provided basis for them, if they wanted to reverse themselves, to justifiably review that decision. He did not actually ask for a review. He tried to tell them that there was an accidental slip or omission, which is one of those cognizable grounds on which the court can revisit, by saying to them, there is a missing 100,000 votes in excess of what should have been returned. And this judgment cannot be justified as being the intention of your lordship if you cannot account for 100,000 votes. And the language he adopted, he did not tell them that it is a nullity. He did not go and start reviewing the judgment of the trial court, the tribunal, or court of appeal. He was just focused on their own decision. And I think that worked magic in probably winning over to his side at least one of their lordship, Justice Nweze. And if you can convince one of their lordships with your argument, it means that there is some form of merit in your argument. And it will not justify slamming you with heavy cost or cost at all. And that's why you see in the judgment, the lead judgment of my Lord Justice Ariwola, he made no order as to cost, because they saw that there was a persuasive content in the case made for Ihedioha.
Certainly there was, and there was merit that was seen there. But what's interesting here is it looks as though the Supreme Court made a judgment more based on the fact that they had to, or felt they had to, insist on their finality. And that is what everyone was waiting to see. Were they going to insist on their finality? What does this mean going ahead when we're looking at our electoral process for politicians, for political parties, for all stakeholders involved in the process? What do you think this means?
Well, it shows to us that there is enough brim to go around. For instance, in a case of this nature, I would have wanted my Lord Justice Nweze to go further, because under the Electoral Act, there is power in the court to recommend criminal investigation and sanction. If indeed something happened about those results, officials in INEC who could not explain how these results emerged ought to be recommended for investigation and prosecution. Officials of political parties who participated in the election, who claim to have been monitors of the election or observers, ought to have something to say in explaining how this happened, and the whole country is embarrassed. Now, beyond that, it is not unusual for Supreme Court sometimes, by their own interpretative jurisdiction, to expand the law beyond what ordinarily the literal rule would suggest. Where that happens and it serves a public policy interest, what should follow is that the Parliament should intervene and then amend the law to either clarify the law on that point or to adopt and endorse the view of the Supreme Court. I wish that, based on this judgment, there should be some legislative intervention very soon. Now, I'll give you two examples. In the case of Sokoto, Dingiyadi, and Wamako, where the Supreme Court took over the Supreme Court of Appeal election governor when it was not supposed to be before them. It was like this. There was a 6-1 judgment. Justice Mahmoud Mohamed, the presiding justice, dissented that they had no power to take over the case and then dismiss an appeal election petition. That position of Justice Mahmoud eventually became the basis for the second alteration to the Constitution, where officially now the Supreme Court was vested with power to hear appeal in governorship matter. It shows you sometimes the power of dissenting judgment. Now, the next one is Faleke and Bello from Kogi, where the governor-elect died before conclusion of the electoral process. And the question arose whether the deputy could succeed to the votes or a new election be held where the party would nominate another candidate. There was an opinion from AG which appeared to have swayed INEC, and they allowed APC to nominate a new candidate in the person of the current government. At the end of the day, the Supreme Court upheld that process with a dissenting judgment, and at the end, and eventually they had to amend the law, now formally authorizing, permitting political party to nominate afresh a candidate in the governorship election, where midway it is truncated. That shows you that the original judgment of the Supreme Court was a judge-made law, and the law had to come later to validate it. So I suppose with Justice Nweze's voice will continue to resound until something concrete happens by the legislative arm. So that is the value of the dissenting judgment in this case.
Well, I'd like to refer you to something you said earlier when you were quoting Justice Nweze, and I'll quote him also. He says, this decision of the Supreme Court will continue to haunt our electoral jurisprudence for a long time to come. Now, what are the implications that he may possibly be referring to?
The implication is referring to is the uncertainty in the law as to who is the winner of an election, which this judgment has introduced. I explained earlier that the person that was returned by the Supreme Court in their judgment came forth in the election. And there is no attempt to explain why the person that came second and third were not the persons to be returned. Because in a situation where you have the winner of the election having his election overturned, you will expect that if it's an outcome that determines that warrants another person being returned.
Pardon me, Mr. Owonikoko, I do beg your pardon.
On the ballot.
I do beg your pardon. Please hold your thoughts. We have to take a short commercial break, and we'll be back with more with you. Please stay with us. Welcome back to the morning show here on Arise News. We're still linking up with our Abuja studio with Mr. Abiodun-Jelili Owonikoko, SAN, lawyer and attorney serving Lagos State in appellate practice. And we're talking about the Supreme Court decision with regards to Mr. Ihedioha affirming the governorship of Mr. Hope Uzodinma. I wouldn't say the election of. But as you were saying, sir, please continue.
Yeah, thanks. You were asking about the caution in the judgment of my Lord Justice Nweze. And I just was trying to draw our mind back to history, that in fact, in the first two amendments to the Constitution were responses to pronouncement by the Supreme Court in respect of our electoral process. The limitation of time to conduct electoral cases was a response to observation by the court, lamentation that cases for election will last for 5 years, even beyond the tenure of the elected officials. And they are restless, unsettled in office, trying to defend their mandate. This led to the introduction of the amendment to the Constitution limiting time within to conduct election. If you remember also the case of Mr. Rotimi Amechi, he had issues with his nomination in his party while election went on, and somebody else was returned. Eventually, he won at the Supreme Court, and he was sworn in based on this kind of consequential order. Parliament responded by now making an amendment to the electoral, saying that if you did not participate at all the stages of the election from primaries, you cannot be returned based on litigation. So that shows you that we have always proactively reacted to developments in how the courts apply the law. I believe this pronouncement by Justice Nweze will not haunt us for too long, because the Parliament has always shown readiness and eagerness to entertain reforms in our electoral law, because probably they are stakeholders in that. We are also going to be appealing to academics and electoral reform advocates to take up this matter, and let us do it in the constitutional way by getting the law to be streamlined and clarified on this matter. I think if that is achieved, Justice Nwese will not have spoken in vain.
Thank you so much for that. You know, glimmer of hope there. A dissenting judgment does not have much precedential weight, but it does have legislative weight, as you said. Something can be made of this debacle, quite frankly. But I want to now take you up on the public perception of the Supreme Court. While we do not expect Supreme Court justices to ever play to the gallery, this has left quite a bitter taste in some mouths, including the most ardent of APC supporters, who would have liked to win fair and square at the polls. The Supreme Court I would have said, our most unassailable institution. But now we have this spate of bad press with regard to the Supreme Court because it appeared that the will of the people has been done. We all know the way elections work. When we look at the composition of the State House of Assembly of Imo State, and we see most of the seats went to PDP, 13 seats, I believe, APGA won 6, Action Alliance won 8. Those are the 27 seats in the Imo State House of Assembly. APC did not win seats. APC got seats when this judgment was pronounced in January, and there was a mass defection from PDP to APC. It sort of stretches credulity to suggest in any way that voters will vote for one party for governor and another party as State House of Assembly. This also suggests, as well as that fourth position that Senator Hope Uzodinma was declared, that APC did not have a very strong showing in Imo State, and yet you now have an APC governor. What does this say about the Supreme Court going forward? Is there a need for the Supreme Court to redeem their image, and how can that be done?
Well, I'll say this. The courts do not decide matters based on popular opinion. They proceed based on the facts and the law presented before them. Unfortunately, election litigations are political in nature, and politicians do not take their fate in their hands. They do everything at their disposal to see how they can impact even the judicial process. I have no evidence in this matter to suggest that the courts was politically influenced. But clearly, it is obvious that the court is being unduly politically pressured by the nature of cases that come before them. Notwithstanding that, I don't think we should judge a governorship election based on how many seats a party won in the House of Assembly. Because don't forget that in Imo State, the governor that just left was an APC governor, and he had majority in the parliament. And along the line, he had a divided platform. His son-in-law contested on the platform of AA, while he contested on the platform of APC. And then I guess they collapsed their structure, and something must have happened. I must confess that I was in the team for Uche Nwosu in his governorship election. Unfortunately, it was this issue of divided platform that cost him his seat, because when the pre-election got to Supreme Court, the Supreme Court had to tell him that it was nominated by APC and AA, and therefore he had no leg to stand. When the governorship election got to Supreme Court had to ask them to withdraw their own appeal in the light of their judgment on this pre-election matter. So there are a lot of complex perspectives and dimensions to what happened in Imo State. And I don't want us to reduce that to whether the Supreme Court deliberately, which I doubt they would, decided to steal people's mandate and give to undeserving candidates. Nevertheless, the court has to now be conscious that the populace is now very, very articulate, and they are watching what is going on. Ordinary people can decipher judgment of Supreme Court and critique it without being lawyers. And some of the things that stand logic on their head make it difficult for one to be comfortable defending their decisions. I believe lessons have been learned, especially in the circuit of these Zamfara, Rivers, Bayelsa, and Imo State. But lawyers, more than the courts, ought to play their role. When you have a case that is bad, don't test the system to its limits and then begin to lament at the end of it all. If votes were spirited from nowhere, there should be consequence. the fact that the governor has been returned does not mean that INEC and the law enforcement agents should not investigate where those votes came from. So that for future purposes, there will be a deterrence, even not from the court, but by the consequence that those who perpetrated whatever injustice faced. I think that's another area we must look at. The impunity that we allow to fester, even when the judgment of court does not prevent the state from taking actions to reverse them.
Certainly. I like the fact that you brought up the importance of not testing a system to its limits, the role of lawyers and the role that they have to play in all of this as well, because that's a very important angle. Now, what's of serious worry now is how all of this is going to play out, of course, in Imo State. Ex-Governor Hedyo had served for 5 months. He looked like a very favorable governor to the people, seemed very likable, seemed as though he was making a lot of progress already in the state. How do you think this is all going to play out in terms of peace, progress, prosperity for the people of Imo State, who, of course, are now having to start again, if we can put it that way?
Well, I'll just say this. After the Supreme Court has spoken, I think all responsible politicians must conduct themselves in line with the pronouncement of the court. Otherwise, the alternative, which is anarchy, does not bode well for anybody. I'm not too quick to judge elected officials as to what they do when their election mandate is still under contest, because we normally see a reversal of commitment once they know they are settled in office. That does not take anything away from saying that it's obvious that in the short time that the gentleman was in office, he tried to carry the people along, and I hope the new governor will learn a lot from that. So, because at the end of the day, it's value for the people that matters. It's not just their own personal aggrandizement or self-promotion. If the new governor can borrow a leaf from the past governor, the one that is unseated, and then improve, it should be an improvement of what those two governors have done. It should not be repeating what they have done. It should be improving upon what they have done. And that's the whole essence of having periodic election, so that populace can have when to test different candidates and then see who can add better value to their lives.
Well, I was very happy when you referred to lessons, and you said quite a lot. But, you know, are there lessons also that, you know, we can learn as stakeholders from the Zamfara case, the Rivers case, the Bayelsa case, the Imo case, particularly all the stakeholders involved, the voters, INEC, the litigants, the Judex, and also lawyers. As for lawyers, well, I don't know about whether or not they would not be tempted to test the limits, because we had a guest once who was once here who told us that election season is time when lawyers, you know, make money from election petitions. And if anybody brings any matter, you know, any lawyer will be favorably disposed to take up the matter, whatever the outcome is at the end of the day. But that's by the way.
No. Hello.
Hello, did you hear me?
I'll just say this, that
yes.
Lawyers practice based on rules of professional ethics. I would say to you now that when we were engaged by Uche Nwosu and we reviewed his case, we made it clear to him that he could not get a return. But that he could get a rerun because we saw that Mr. Iheda did not have the spread. He did not have the 1/4 of votes cast in 2/3 of local government in the state. And so our case from day one was not for return. So you can imagine the embarrassment we are suffering today, that even someone that came forth after we had advised our own client that he could not get a return, ended up being returned. So just like you said, but it is the duty of lawyers, and we will continue to emphasize this, not to pursue lost causes just because of pecuniary gain. In some jurisdiction, lawyers who press that kind of case will have to face disciplinary consequences of their profession. And I think we should move in that direction now. Some cases are not worth being pressed. Our professional ethics says that even if you think you have a good argument, if the authorities are clear, you should refuse a brief where the client is simply insisting that you should use the judicial process, you know, for untoward purposes. I believe that such light should be beamed on lawyers who engage in those kind of things now. That's on the side of lawyers. But more importantly, politicians, they must subdue this their do or die attitude to elections. Because you can see how many years is General Buhari tried to become president, I don't think along the line he ever thought the chance was still there. But the chance came. And that's because he allowed the system to be sustained. So we should all know that the system is big enough to accommodate all ambitions in the fullness of time. And I would advise that we should not allow this system to collapse. It is our own mandate to enrich it better than we met it in 1999. We should not be going backwards. That's my own suggestion.
Absolutely. And just a slight contradiction there. I don't think you have any reason to be embarrassed about the advice that you gave your clients, Uche and Wosu. You can hold your head high because you served your profession honorably, unlike some people that we won't bother to name. Now, is the writing on the wall for APC's application with regards to Zamfara, since we now have a spate of Supreme Court judgments where they have refused to reverse their decisions?
Well, that's the kind of thing I'm talking about. After the court has constantly taken a stand like this, unless you can, it's not that you cannot go, but you must have a special circuit that takes your own case out of that context to say that, look, I have a different argument that I think your lordship may be interested in listening to. And then with the result that you may come to a different conclusion. But if you are coming to argue the same kind of argument that others have canvassed in Bayelsa and Imo, I would think that a lawyer worth his salt will begin to now do a rethink about whether it's worth being pursued. Don't forget, other cases are suffering because of election matter. By the constitution now, there should be no election matter pending in Supreme Court. Because the time, which is like a rock of Gibraltar keeps for election, which is like a whole year that the entire judiciary is devoted to election matter and other cases are suffering, has lapsed. We should allow other people to have their day in court. Commercial cases are pending. Constitutional cases are pending. Criminal cases are pending. Some people are in the gallows waiting to know their fate. We should allow the Supreme Court now, having cleared this hurdle, to face the normal cases in the system. In fact, it's an embarrassment that we spend a whole year fighting the outcome of election. In some countries now, if you check their law report, go to UK, you can hardly find a law report on election matter in the last 30 years.
Well, thank you very much. Owonikoko SAN, thank you very much indeed.
Thank you.
We've been greatly enlightened this morning.